everyone. Thank you so much for being here with us today. The introductions are coming into the chat. It's great to know more about who's in our virtual room, where you're coming in from, what industry is your business in. This is great. I am Katherine Walker, the Assistant Director of the Women's Business Center of Northern Virginia. Welcome to Trademark 101, Basics for Entrepreneurs and Small Businesses. This is going to be facilitated by Tammy Hui of the Geller Law Group. Before I hand things over to Tammy, let me share a little bit about women's business centers and some housekeeping for today. So this webinar is in partnership with two women's business centers in your region. I'll introduce them in more detail momentarily. Women's business centers are funded in part through a cooperative agreement with the U.S. Small Business Administration. We do serve all genders through a variety of services such as business counseling and business training. Each women's business center is unique and special. We're all across the nation, multiple in Virginia, multiple in Maryland, etc. But please connect to your local women's business center. They're really valuable resources. We're here to support your business journeys. So specifically today's partners. So I'm with the Women's Business Center of Northern Virginia. I'll make sure to put our website into the chat. We have a few upcoming programs at the WBC of Northern Virginia, including on July 17th, we have an in-person program in Arlington. For those of you who are in the Virginia region or around Arlington, please join us. It's going to be the pivot point, turning your layoff into your business launch pad. So this is going to be designed for professionals displaced from federal or private sector roles. So people who might be interested in launching a freelance gig, building a profitable startup, want to found a mission-driven nonprofit, you're going to learn a little bit about how to evaluate your ideas and learn about some of those first concrete steps that you can take. And then on August 4th, we're going to be doing networking with confidence, real strategies for small business owners, and that's going to be a virtual opportunity. The Maryland Women's Business Center, marylandwbc.org. They have a few physical locations, including Rockville and Bowie, but just like us, they offer both virtual and in-person opportunities. On July 15th, they have a virtual webinar called First Impression Sales, How to Win More Deals in the First Meeting. So if you're in sales, this is going to be about prospecting. So it looks like an awesome topic on July 15th. And then July 22nd and 23rd, they're going to have a part 1 and a part 2 virtually, marketing to federal agencies for beginners. So I'll be sure to include our information in the chat if any of those programs interest you. Logistics for today, we highly recommend using the questions box for questions. I'll continue to monitor that throughout. A lot of you are continuing to do your introductions in the chat. Keep those coming. We're thrilled to know who's in the virtual room, where you're coming from, what industries you're in, etc. For questions, we're going to likely address many at the end, but Tammy might give me the okay on politely interrupting her throughout if there's a relevant question on something that she's currently covering. There's a good number of attendees. We should be able to get to all questions, but if we can't, I'll do my best to provide more information as to how to learn more, but we'll certainly do our best to answer all questions that come in. We will be recording today's webinar, and Tammy's given me permission to provide the slides, so please expect a follow-up email from me over the next few business days that includes the recording, slides, etc. So our speaker for today, Tammy, is partner and serves as the chair of the Geller Law Group's business practice. Her practice focuses on providing business services to small businesses and nonprofit clients. Tammy also handles trademark matters, assisting and counseling clients on trademark clearance and enforcement through the process of preparing and executing the trademark application. Prior to joining the Geller Law Group, Tammy owned and operated a solo law practice serving small businesses and nonprofit clients in the Washington, D.C. region. She previously served as an in-house counsel to an environmental nonprofit for 8 years, where she was embedded in the day-to-day operations of a dynamic global organization. So I wanted to include all of that because she obviously brings great depth and diverse experience to this arena, and we're thrilled to have her back today covering this topic. So with that, Tammy, I'll hand it over to you. Thank you so much for being here.
Great. Thanks, Catherine. Thank you for the kind introduction and the opportunity to present on this topic again. We did this a couple years ago, but there have been some updates. And so I was happy to be able to give an updated version of this presentation, and I'm so glad to see all of the businesses represented. Thank you so much for contributing to the chat. I've been writing down notes, so I can remember and reference that as I go. I wanted to thank Catherine and the Women's Business Center of Northern Virginia, and also this time the Maryland's Women's Business Center as well, for having me. So I'm so excited to be here and share on this. I think it's exciting, but I'm a bit of a geek. So on the topic of trademarks with you all, I hope you all can take something out of it that's going to help you in your business or venture, what have you. Whatever you're doing, this is kind of a fun topic, I think. So I'm going to share my screen here um, and get going. Okay, so bear with me. All right, so we're going to talk about trademarks, as we've already said, and it's focused on entrepreneurs and small businesses today. I will start with, of course, as soon as my slide advances. Oh, here we go. Uh, a short disclaimer, since I'm a lawyer and we like to disclaim everything we do. I can't move on without it. So, this presentation is made for informational purposes only, and it's not intended to convey or constitute legal advice. It doesn't create an attorney-client relationship, although I would love to have one with you. We can talk about that afterwards. It's not intended as a solicitation or all-inclusive statement of the law, and it is not a substitute for obtaining legal advice from a qualified attorney about your specific case. Okay, got that over with, and we can start right now with a little bit of an overview of what we'll be discussing today. First, I'm going to talk about intellectual property, what it is, what the types are, and then we're going to zero in on our topic of the day, trademarks. What is it? What can be a trademark? We'll talk about common law versus registered trademarks. And then we'll move into the trademark registration process. That is the process here in the US. And then afterwards, we're going to talk about post-registration and business considerations. Once you have your trademark registered, then what? So we'll cover a little bit of that too, and get into some practicalities of what to do after you've registered your trademark. All right, so I do have a couple of poll questions today. So hopefully you've joined on a laptop and have your phone handy. It's really easy to answer these questions. You can just scan the QR code and it should pop up in your web browser, and it'll allow you to type in some answers. So the first question is, what are you hoping to learn from today's webinar? I gave you a little bit of a roadmap. I saw some uh, folks in the chat who have already um, perhaps registered some trademarks. Um, and so, uh, this might be an update or a refresh. Um, and so great. What can be trademarked? We will definitely cover that. Logo trademark isn't necessary. Great. We can address that. How to start my trademark, how to start the trademark of my business name and logo. Need to learn the basics of trademarking. I have no idea. That's great. And then we'll definitely cover that. How trademark works and what they protect. How to register my business logo and trademark. Great. What do I look up the name of my business idea? And there are over 1,000 results. Do I need to expand the name to differentiate it? How long does trademark last? These are great. We will try and cover all of these. I am new to entrepreneurship and would like to learn. Whoops. Sorry. I was trying to scroll down to see if I could get more answers showing, but oh my gosh. Uh, sorry. Messed up the slides. Okay. What needs to be trademarked? And then beginning of the process, can you trademark prior to registering to put people on notice? Okay, well, these are great. Unfortunately, I don't know how to, I don't know if I can sort these responses. They're all different. Oh, oh, wow. Look at that.
What a cool feature.
I know. I mean, I think they've added some AI to this, so that's pretty cool. Well, thank you so much for participating in this first question. We'll move on to the next question. A lot of you already put in what your business name is and your URLs. Um, and I think the poll might have put you onto the next question when I accidentally flipped. But um, I'm interested in knowing where you are in your entrepreneurship journey. Are you just exploring? Are you ready to launch? Have you just launched in the last 3 years, or have you launched more than 3 years ago? All right, great. Looks like we have a bit of a mix, and I'm gonna wait for a couple more minutes to see who wins this race. Exploring, oh, newly launched is pulling ahead. Well, that's exciting. I mean, you're still in kind of the beginning stages. And then we have some folks who have been doing it for a while. I know 3 years is kind of a low threshold for established, but I mean, it is, I think there is a bit of a hump over the, first 5 years at least. So, um, great. A lot of people who are kind of in the first few years, 0 to 3 year range, and then a couple people who are exploring, or four rather. All right. Well, great. Thank you so much for participating in this poll. It's great to know a little bit more about, what stage of business you're at, before we dive in. All right, so intellectual property generally is are creations of the mind, such as inventions, literary and artistic works, designs, symbols, names, and images that are used in commerce. Um, Intellectual property, or IP as it is commonly shortened to, refers to intangible assets that differentiate your business and may encompass everything from your company's brand name, logo, slogan, innovative technology, or proprietary designs, recipes, processes, what have you. IP is a key driver of economic growth and innovation in business. In an increasingly competitive and crowded market, IP protections incentivize businesses to keep pushing for new advances. This is especially true now in the world of AI. AI is supercharging innovation in a way that we haven't seen before. Like people are finding creative ways to use AI and just boost their creativity and innovation. So it's kind of a really exciting time to be in existence. Exciting and scary at the same time, I will say. So intellectual property is really important to your business because it is what makes you unique and it's what helps you generate income, based on, what you have to offer. So whatever is distinct about your business. Consumers also trust IP to provide them with safe and authentic goods and services. And that's what we're going to talk about today with trademarks. So there are a few main types of intellectual property that you have probably heard of. And a lot of times when folks talk about IP, they might throw these terms around. Some of them get conflated. So I just wanted to set us straight on what does what. So copyrights protect original works of authorship. They are things like literary works, musical compositions, motion pictures, sculptural works, computer software, in terms of the coding, and also how it's presented. The thing that is coded, how you see it visually, the end result, architectural plans, and it has, many more things like that. They have a long but limited life. So it's usually um, 70 years after the life of the author plus 70 years, for, works created by individuals. For works for hire, um, I'm gonna get this wrong because I don't know by heart, but it's longer. It's something like the So works for hire are things that are commissioned by others to be made. So if I hired you to paint a painting or if I hired you to create a logo for my company, it's 150 years after it is first published, something like that. Don't quote me on that. I should have had that prepared. In any event, there is a limited life to copyrights. And so, classical music, those guys who and gals who wrote that music are long gone. So those copyrights have expired. Um, so that's why anyone can take those musical works and record them. The recordings, anything that's recorded is new and can be copyrighted in and of itself, but the original music itself is no longer subject to copyrights. There's also some exceptions like the government, anything that is produced by the federal government in the US, it doesn't have a copyright on it because it is public. It's owned by the public, the government owns it. So any, images or, websites that are produced and published by the government, um, the US government doesn't have a copyright on it. So that's copyrights. Trademarks uh, identify the source of goods or services in the marketplace. And with continued use, they can last forever. So if, a trademark for a company like Kellogg, which has been around for a long time, um, that it can go forever as long as Kellogg is using that mark. Um, so trademarks, I like to think of them as brands. So it's the brand recognition that, trademarks protect. So that's a little bit different from copyrights, which um, prevents people from on unauthorized copying of the work. So copyrights protect from unauthorized copyright or copying. Trademarks are the brand and help people identify where a good or service is coming from. Patents are government issued monopolies for new or non-obvious inventions. So they can be things like processes, machines, manufactured items, composition um, of matter, um, and they last 20 years from the date the application is filed. I do not do patents. It is a very specialized area of the law. You have to write a separate bar exam. You have to have some sort of scientific, medical, or engineering background in order to become a patent attorney because you need to be able to understand what it is that you are trying to protect or help somebody protect in terms of, submitting a application for registration of a patent. So those are pretty technical and they're for non-obvious inventions. So essentially, there are things like things that are subject to patents that you might commonly think of are pharmaceuticals. So new drugs, they often have a patent on them because they do something that hasn't been done before. And there's a protection of the patent that allows the patent holder to monetize the new thing that they have created and control who might be able to use that new thing that they have created to make money. So that's why it's called a monopoly in terms of this definition here. Trade secrets, and that's the fourth most common type of intellectual property that you might hear of. They are formula, practices, recipes, processes, customer lists, etc., that are protected and maintained as secret information in a business. So the quintessential example of a trade secret is the formula for Coke. It is under lock and key in a safe that only can be opened by a board resolution. It is locked down. So that is something that, the company treats as trade secret, it doesn't share openly, and you know, is protected in a way that no other types of information are. So they'll do things like you can't just write it down and leave it out in the open. You have to have it protected. No person within the company has all of the pieces of the whatever the trade secret is. It's always kind of dispersed. Knowledge is dispersed among, various departments or people in the company so that nobody has it all in one place. So the company will take measures to keep that secret. So the first three here are all things that can be registered. Trade secrets are not something that you register because when you register it, you are disclosing it. And so trade secrets are different in that sense, is that you do keep it secret, you don't register it anywhere, it's just kept internal to the company. Um, okay. I wanted to see if there's any questions. This might be a good place to pause.
There are
There,
questions. One is about the TM symbol, so I'm not sure if that's something you'll cover coming
I
up.
will cover it.
Okay, perfect.
Yeah.
So we can come back to that one.
Okay, great. All right, so we're just going to move on to trademarks, the main event. A trademark is a word, name, symbol, device, or any combination of these that is used to identify the source of goods or services in the marketplace. So it's how consumers recognize a business or its goods or services. So a trademark can be the business name, or it could be the brand or name of a good or service that is provided by the company. And it's used to distinguish your business from other competitors. A trademark can refer to both trademarks and service marks. You might have heard of a service mark or seen the SM indicated somewhere beside a service mark. Trademark is kind of an umbrella term that means both. There's service marks. It can are specifically for services, but trademarks can mean goods or services as well. A trademark has two basic functions. First, it protects consumer expectations. So it prevents consumer confusion, fraud, or passing off of, goods or services using somebody else's mark. So if I wanted to create a computer, I had a computer product, I couldn't name my brand Apple because then there would be some confusion out there of who has created this computer. I mean, they set a very high bar in terms of quality, and so that's another factor is, protecting consumer expectations. If I were to name my computer company Apple, if it's no good, then people aren't going to really confuse it, but it might damage Apple's reputation because my computer is not as sophisticated or as sleek as potentially an Apple computer. The second thing that a trademark does is that it protects the trademark owner's investment. So it gives the owner control of the goodwill or reputation represented by the mark. So it's an important asset. What can be trademarked? I know there was a question in the initial poll, a comment in the initial poll question. Um, with respect to this. And so there it can be a lot of different things. It can be a business name like Ford Motor Company, a logo like the Target logo here, a brand name. I think that was Lay's, a product name like Oreo, tagline or slogan, just do it, is a very well-known one. We all know that's Nike. Trade dress is the shape of something. So the example for this was the Coke bottle. That is actually trademarked. So when you see this shape, you know it's a Coke bottle. And they've used this shape for a long, long time. But it is the only soda that comes in the shape of a bottle. Because the trade dress, what the packaging is a trademark. Hashtag, it's not as common nowadays, but it can be a trademark. There were, a while there where hashtag marketing campaigns were a thing. They're not as popular anymore, but they're still out there. It could be a sound. I didn't have the sound play, but one of the sounds, the example here is the MGM lion roar. That is trademark of MGM. The NBC chimes, the dung dung dung, is also a trademark of NBC. a smell. The smell of Play-Doh is trademarked. I know anybody who's ever opened a jar of Play-Doh knows that smell. Um, and to submit it for a trademark registration, they had to describe the smell. So I don't know it offhand, but you can look it up and see how they describe it. I think it has something to do with vanilla in it. And then a color can also be a trademark. So the Tiffany's blue is a trademark of Tiffany. So if you ever you see this little blue box, you know that it's from Tiffany's, and something good is inside. Uh, so these are the things that can be trademarked. Most small businesses will register their name or logo and perhaps a brand or product name or a service name. The other types of trademarks, I mean, uh, registering a trademark is a bit of an investment. So, given that, if you are a small business, you are probably really trying to be cost effective. So, you're not going to register all of the things. So, you got to be strategic in where you spend your trademark registration dollars, and brand protection dollars. But these are just some examples that I think are really fun to think about.
Can
Here's some
I
question about,
Oh,
yeah.
sorry. Yeah, I was going to interrupt because you said you were trying to say consider what you're going to get trademark. You might not do everything. A good question that came in that's aligned with that, and maybe you'll
Mhm.
discuss it, is does it make sense to request the trademark for the name, the logo, the tagline, for example, at the same time?
Yeah, that's a great question. I'll get to that in a little bit, but that is a great question. I mean, it goes to strategy for your brand protection. Okay, so common law versus registered trademark. Somebody did ask about the TM symbol, and so this is where that question gets answered. Um, So there in the US, trademark protection begins when a mark is used in commerce. This is known as common law trademarks. Um, these are these rights are geographically limited and they're not as easily enforced as a federally registered trademark. So if it's unregistered, it's known as a common law trademark. Somebody's just started using a mark in commerce, which is common. It happens all the time. I start a business. I have a business name or a brand, and I start business. And, that is a common law trademark. Um, there are, as I said, geographic limitations. It is, in this day and age, a little trickier to use a common law trademark and keep a common law trademark protected because of the internet. Everybody is everywhere. So your geographic limitation is not going to be as strong of a limiting factor in terms of common law trademarks, and there being a lot of common law trademarks being used in different locations. Unless you're a hyper local type of business, like and have to be brick and mortar, um, and there's no sort of like e-commerce part component of your business. Common law trademarks are really hard to protect since almost everybody has an internet presence these days. Um, so these, of course, um, common law trademarks, as I said, could be indicated by using the TM symbol. So if you've ever seen a little superscript TM or like beside or under something, it means that it is a common law trademark, and it's not registered. And that's, a typical use of the symbol. And I'll get to the R in the circle symbol on this slide just a contrast between the two. So trademarks that are registered with the U.S. Patent and Trademark Office become registered trademarks. And to be registered, the mark must withstand the trademark registration process. It is, I think, longer than most people think it might be. But, they do need to make sure of a few things in terms of it being distinctive. And not being confusingly similar with another mark, either on the registry or on the registry. Um, Registration establishes a public record and provides notice of important facts relating to the ownership, such as the dates, the dates of use in commerce and the goods and services offered in association with the mark. So that's all of the types of information that goes into the registration. There's more, but these are, the very the salient details that, everybody would want to know about. It once you register it, it provides national protection for the mark and it allows enforcement of the owner's trademark rights in federal court. So if somebody were infringing on your mark, you could enforce it by filing a lawsuit in federal court to protect it. Um, Registration with the USPTO can also be a basis for registering the trademark in other countries. There are international trademark treaties. If you get to a point where your business is operating in another country and you want to be able to protect your trademark there, then you can use your registered trademark as a basis for filing in another country. And it also happens the other way as well, since the US is part of these treaties. There are marks, of companies that originate in other countries, and they can use that treaty as a basis for filing their mark in the United States if they're thinking about entering the US market or they are already in the US market. So while the trademark protection is just geographically limited to the US, of the USPTO, you do have some foreign trademarks coming in and registering their marks with the USPTO based on their registration in another country. So um, there's usually a timeline during which after it's freshly registered in the other country that they have an opportunity to use that as a basis to register in another country. Um, and then the last point here is that only registered trademarks can use the R in a circle symbol. So the R, if you see in the little corner of this slide here, that indicates that it's been through the whole process and it made it through. It is a registered mark and you have the certificate to prove it. Um, if you use the R in a circle symbol without having registration, then it's really frowned upon and there could be some penalties and things related to false advertising in terms of the mark and so you don't want to be using the R in a circle if you don't have it registered with the USPTO. You can use the TM symbol instead before you have it officially registered. Okay, so we're going to talk about the trademark registration process. So here's an overview. First, you're going to have to choose your mark. Then I typically recommend a trademark clearance search. It's not mandatory, but it's important for a couple of reasons that I'll get into. And then the process of applying for your mark is called trademark prosecution. And there are a few steps within that. So you have to prepare and file your application. It goes to examination with a trademark examiner at the USPTO. And then if it passes that, then it goes to publication. And then if there's nothing that comes up through the publication stage, it will register. And we'll talk about these steps in a little more detail coming up. And then after you've registered, it's kind of in a maintenance phase, and there are intervals at which you have to file paperwork to maintain your mark registration with the USPTO. So choosing your mark. I always say I am a lawyer and I'm not a marketing person who is great at choosing marks. So don't ask me what had to come up with a mark. I would be terrible at that. But I can tell you whether or not you can register it. So questions to think about is, does this mark infringe on someone else's trademark rights? Am I investing a mark that I can own? Those are kind of the legal flavored questions. There are other considerations, of course. And these also are with respect to the mark itself. Is it distinctive? Is it a strong mark? And we'll talk about what that means coming up. Does it function as a trademark? So some people like have things that they like to put on t-shirts. If it's a saying or a slogan that they really like and it's kind of their mantra, they're putting it on a t-shirt. Sometimes it's not actually functioning as a trademark because it's not a brand. It is just ornamental, and the trademark office will refuse applications for marks that might be considered ornamental and not functioning as a trademark, because it has to be used as a brand. So usually it's in big letters, it's on the tag of a shirt. If you know that's what they look for when you have to submit your specimens of use, which is basically evidence of how you're using the trademark. Is there a crowded field? Are there a lot of people who are using the same type of mark in terms of the words or combination of words with respect to your goods and services? Is it generic or descriptive? We'll talk more about that coming up. Other factors to consider: is the domain name available? Are the social media handles available? And those are just kind of the more marketing related factors associated with choosing your mark. There are three types of marks, or generally three types of marks, and this kind of goes to that question of, what do I register? Do I do the word, design, composite mark? So I'm going to tell you what the types are, and then we'll talk a little bit more about strategy. So the word mark is a mark that is comprised of one or more words rather. It's just the plain words, and the trademark office calls this the standard characters. And there's no claim to any sort of specific stylization. So there's no specific font, no specific color. And this is the most versatile type of mark because the word or words in that combination can be depicted in any manner. Um, Design mark. This is a mark that is a design without any text. So, like the Nike swoosh. The design is protected as is and cannot be materially changed from what is registered. Otherwise, your registration cannot be maintained because in order to maintain it, you have to show that you're continuing to use it. Um, so design marks are logos essentially. If you do not claim a color to the design mark, the mark can be used in any color in your marketing. So if you claim the color, only that color on the mark is going to be protectable, which typically doesn't work if you have like a mark that is in a specific color, but then you want to show it on a website on a dark background and it doesn't show up because there's not enough contrast. So typically I'll say disclaim the color. You just submit a black and white, you just claim the color, and so you can use it in any color that you want. Composite or composite mark, depending on how you like to say that word. It's a mark that is a combination of a word and a design element together, or a mark with a claim to a specific stylization. So the composite is protected as is, kind of like the design mark, and it cannot be materially changed from what is registered. Otherwise, the registration may not be maintained. So some composite marks have like a design element and then words. And so if you have it in this configuration, design words, then that is what you register. If you use it in design and words to the side, then that is a different composite mark. So it's very specific to what you submit to the trademark office. So based on this, um, it is typically, I would say, your word mark is most versatile. You can use the word in any font, any style that you want. You can make it into a stylized word, and that would still be protected if it's just the word or words of your mark. So, strategically speaking, I pretty much always tell clients like your preference would be for the word mark if you had limited dollars to spend on brand protection. Design mark, if it's a design that you're going to use for a long time, sure, and you have the money to do it, go ahead. The composite mark, if you have the word and design separately protected and registered, putting them together still means that they're protected because each element is protected. So obviously, some composite marks are, you're going to want to protect them. And so, these are cases that I would talk to a client about in terms of strategy. Sometimes if a trademark search doesn't come back clean and there are some concerns about the particular mark that you're trying to register, you might have to pivot to something that's not as versatile as a word mark. So it depends, but this is usually kind of the approach that I would take, all things being equal, as in like there's no other marks that are problematic that come up in the trademark search. So here are just some examples. Word mark, these are Samsung, Coca-Cola design marks, those are just the logos, and the composite marks um, are stylized versions of the marks. So IKEA, I mean, there's the word in it, and then the design part, and then ASICS, it's got the little design part and the word to the side. So ASICS also has just ASICS as a word mark protected. And most brands will have that separately protected as well. Okay, so this slide is called the spectrum of distinctiveness. It's it's a really grand slide, but it shows a lot in terms of how protectable a mark might be. On the left, you have the red zone. So these are kind of the marks that you would probably want to stay away from and are not as strong as marks that are in the green zone on the right side of this slide. So starting with the red zone, generic marks are things that are describing the exact thing, the good or service that you are offering under the mark. So a mark like cornflakes will be too generic to register. And if it's found to be generic, you cannot register it at all. The USPTO will say, nope, sorry. Um, and you say cornflakes. So these are flakes made out of corn. And that's why the USPTO are like, it's too generic. If you register it, then nobody else can ever use the words cornflakes to describe flakes made out of corn. I had a client come in and they wanted to register family trip guides for a website that had tips and tricks for, a travel guide for family trips. And the USPTO said, no, that's too generic. You can't register that to just, in association with your website for like travel guides for family trips. You might ask, what about like cornflakes for like the little rooster, Kellogg's? Their mark is actually Kellogg's cornflakes. So the Kellogg's makes it different from just cornflakes. Like they had to what's called disclaim the words cornflakes. So really the distinctive part of Kellogg's mark with respect to cornflakes is the Kellogg's. And that's the brand recognition, the Kellogg's cornflakes. The cornflakes doesn't really play into the distinctiveness of that mark. So they had to add something to make it not generic and therefore registrable. So the next step up is descriptive marks. These are marks that describe some sort of element or characteristic or feature or function of the good or service. So work suites are suites where you work. American Airlines is an airline where that is based in America. Um, and you might say, well, if you hear American Airlines, you're only thinking of one specific company. Descriptive marks, while they are kind of in the red zone, they can acquire distinctiveness over time. How that happens is from continued use. American Airlines has been around for a long time, and they've built their brand and have used it for so long that everybody now knows you're talking about this exact company when you hear American Airlines. Um, so descriptive marks, while they are not as strong and they can be registered and they can acquire distinctiveness over time. Um, the next up from a descriptive mark is suggestive. So whenever you hear these marks, you kind of have to use your imagination to there's a bit of a creative leap to think of what kind of goods and services are offered under this mark. Netflix. So initially movies that were offered over the internet. Coppertone for sun care products. It's the the shade that you will turn if you use these products. So it's not a direct description of the product itself, but you just kind of have to put two and two together to get there. But it makes sense. And these are, heading towards the stronger end of the distinctiveness spectrum. Arbitrary marks are things that might be common everyday terms that are used with regard to things that have nothing to do with it. So Apple for computer products. we all know what an apple is, the fruit. But prior to Apple Inc. using it as a brand for their computer products, nobody ever thought of computers when they saw an apple. So that's an arbitrary use of an apple. Starbucks was a character in the book Moby Dick who really loved coffee, and that's how this name came up for Starbucks. Fanciful are usually completely made up words. So Verizon and Adidas here are both made up words that are a combination of existing words. So those are going to be the most unique. Oreo is a completely made up word. And so those are going to be the most distinctive. Um, and it also can't mean anything in a different language. So if you use like a word that is a actual word in another language, it's not necessarily going to fall in the fanciful category. It might be somewhere else on the spectrum. So, the trademark office will look at English equivalents of marks, and they do ask for translations if your mark is not in English, just so they can do this analysis. All right. So here's another question for you all, just to check to make sure if you're still with me. It is a newer question. Can a business name or logo created using AI be registered with the USPTO? What do you all think about this one? Yes, no way, or I'm not sure. Wait a couple minutes. I just went to an AI innovation and IP law summit last week, and there were a lot of really interesting ideas that were presented in terms of how AI is going to affect intellectual property law. So this question kind of came out of that session, um, because not everybody knows what the implications are, and so I think over the last couple years we've been progressively and quickly exposed to AI, and it's becoming more of a publicly accessible tool that everybody's using. So I would be uh, remiss if I didn't talk about AI because everybody's using it, and I'm sure people are using it to generate, come up with business names, logos. So the question is, can it be registered? All right, so we have a tie between yes and I'm not sure, and a couple of people say no way. And I don't think this is, I think this is pretty reflective of, what's out there. People are still kind of figuring out how AI affects whatever topic they're considering. All right, well, thank you for your responses. I'm gonna go to the next slide, and the short answer is yes. So people who answered yes, great job. Um, and I think there is good reason for confusion out there because people sometimes confuse the different types of IP. So this answer is different depending on what type of IP you are talking about. So trademark law, unlike copyright and patent, trademarks do not require human contribution in order to be copyrightable, patentable, trademarkable. Um, the fact that AI was used to create the mark doesn't necessarily mean that it can't be registered as a trademark. Um, with respect to copyright and patent law, copyright law requires human authorship of the work. Patent law also kind of a similar um, requirement. And those, because constitutionally they come from the intellectual property clause in the Constitution, whereas trademark law comes from the Commerce Clause. And it is, avoiding the confusion in the marketplace that trademark law is getting at. So that's why it doesn't require human contribution. So you can use AI to come up with this business name. You can use AI to generate your business logo, but you have to make sure it still has to meet the requirements of being a registrable mark and all of those things about it not infringing on another person's or company's mark. And it are hold true. you have to remember that AI takes information from the internet, information that's already out there, and comes up with an average response. So, and also the response might depend on what prompt you put into the AI system. So, what did you actually ask it? Um, but just because AI came up with it, and AI is great. It does so many things, but I think, have to approach it with a little bit of caution and use your brain to think critically. Um, because what AI produces sounds really great. It sounds legit. Um, so just look at it critically. What it comes up with, it might not be a strong or distinctive mark. Think back to the spectrum of distinctiveness. If it is describing what you're offering, it still might not be a distinctive mark. So just be careful of it. By all means, use it, but I use it for brainstorming all the time. And it's me and a combination of me and AI. And that's kind of how it works. It's the prompting and then, AI coming with the responses. But um, still do your own kind of searches generally to see if it's something that is distinctive enough. Sometimes I've heard of AI just producing a mark that is just in another language. And if you don't speak that language, you might not know. So just give it a little bit of a vetting there. So I'll move on to the trademark clearance search. Um, that I always recommend. The purpose is to check for existing use of marks and potential infringement issues, and also to assess the likelihood of registration with the USPTO. You can have different scopes of searches. Usually, a knockout search is just looking at the PTO marks. I would always recommend doing a common law mark search just to make sure it's not something that's already being used by 100 other people who just didn't bother to register it. That actually happens. Um, you can also expand the search to international marks, but for the most part, small businesses that I work with don't have international operations. So it's limited to US registered and common law marks. But we'll look at, domain name registries, corporate name registries for all the states, in terms of looking at common law marks and also, just the industry sources for whatever industry you're in. So, there are search tools out there. There's also vendors that, we can use to do the search. You can go on the USPTO database and search yourself. Always do just like a Google search, just to, that's the most basic you can do. And everybody has access to that. So at least type it into Google or a search engine and see what comes up. Um, because you don't want it to be so obvious that somebody's already, come up with it. Um, so the next step, once you do the search, and if it looks like a mark that is clear to use, you would prepare your trademark application for the USPTO. One thing to think about is the timeline. It takes them quite a while to assign the application to an examiner once you submit it. It's about 6 to 8 months, sometimes longer. And then once the examiner gets assigned, then it starts moving along in the process. But in the meantime, you're just sitting there waiting. So what do you do if you're at the start of a business and you want to know if your mark is okay to use? This is why the trademark search is another reason why the trademark search is recommended, is so you can have some assurance that the mark that you apply for and want to start using is likely to be clear to use and register, and that's something that you can own as a piece of your intellectual property um, assets for your business. So, um, the overall timeline to go through all these steps is about 12 months from date of application if there aren't any issues that come up. Um, so that's kind of another thing to think about. What typically happens is I'll have a client come in, they want to use a mark, we'll search the mark, and after the search results, if it's clear, then they go ahead and register the business with that name. If we're searching for the name that is as the trademark that they want to register, and then um, they create the business, and then we prepare the application. The application has to have the owner of the mark on it, and you usually want to have the business own the application. So that's why it happens in that order. So search, create the business, prepare the application with the business as the owner and then submit it and then proceed with setting up all of the other things, doing all the marketing and branding for your business. Um, if you've done the search, then you have some assurance that it's going to be okay and will register. So here's the application. I know I've taken a little bit too much time on the front end, so I'm going to speed it up a little bit. The application, there's a couple of different filing bases. If you're already using the mark, it's you can file it on the use basis. If you intend to use it and you're not using it yet, you can still file an application. It is helpful because you get a filing date, and the earlier the filing date is, the better. It will block any other applications that come on get submitted subsequently that might be similar or related to your mark and the goods and services that you're offering. So the filing date can help you a lot if there is somebody that comes along later. So all of this other information, owner information, a depiction of the mark, the goods or services that are going to be offered in association with the mark, the dates of first use, and specimen for a use-based application. If it's an intent to use, you don't have to submit this because you haven't used it yet. And the filing fee is 350 per class for a base application. So that's either application. If you submit on a use basis, you don't later have to submit a statement of use. That's another 150. So if you file on an intent to use, total fee is like $500. So it's a little bit more. There's some limitations and additional fees apply if you don't have all of required information. They'll kick it back to you and ask for more money. Um, if you have custom identifications of goods and services, the USPTO has their own standard goods and services description. So if you use those, you get to pay the 350. If you have custom written ones, you pay more. And then there are character limitations on that. Okay, so examination. So once you apply and it sits there for a few months, they assign it to an examiner. It gets reviewed by an examining attorney who reviews for things that we've kind of talked about in terms of the distinctiveness. But at the very least, it has to meet the application requirements of the USPTO. They'll go through it. If there's any issues with it or they need more information or they need a disclaimer, they will send you a notice called an office action. Usually, it's 3 months to respond to the office action. If you need more time, you can file for an extension. If any of the issues raised, um, all of the issues raised in the office action have to be addressed in order for the application to proceed. There are some substantive office actions that might be hard to overcome. So this is what we're trying to avoid when we do the trademark clearance search. Um, but assuming that everything is great and you can overcome any sort of office action notices or just provide the answer and move on, it goes to publication for opposition. So this is as part of any sort of public process. There's an opportunity for anyone who thinks that your mark might be infringing on their trademark to oppose your application. Usually this is a formality, but sometimes some aggressive trademark enforcement companies or companies that are very aggressive with enforcing their trademarks will oppose your application. But most of the time, it's fine. Once the publication period is completed, if you filed a use-based application, it will proceed to registration. And then if you um, file an intent to use, then you would file a statement of use to show that you're using it. Or if you haven't started using it yet, you can file an extension. You can file up to 5 extensions, and they're each 6 months each, 6 months in length. So it can be kind of up to 2 years for you to start using the mark. Once it is accepted, then you would uh, proceed to the registration. Once you get the registration, you get this nice little e-certificate. They used to send you an actual certificate, but now it's just digital. You can request an actual one if you want something for your wall, which some people do. Um, so that's the trademark registration process. What do you do now? You start giving notice. Use the R in the circle, update everything, and then you have to monitor and enforce your trademark. If you see there's somebody using your trademark, write them an email, engage your lawyer if needed. But there is a duty to monitor your mark and make sure that it's not being diluted or infringed. And then for maintenance, between years 5 and 6 of the registration, you have to file what's called a declaration of use to maintain your mark. And then after that, it's on at the 10-year mark, and then it's every 10 years after that. So you can keep it going so long as you're using the mark. In terms of business considerations, registering your mark helps protect your business and its earning potential. Um, it's a intangible asset that can affect the valuation of your business for investment or sale purposes. Um, and you want to make sure that you secure the rights to marks that are created by employees or contractors or in a collaboration with others. Um, and then you can use your trademarks and leverage them through proper licensing agreements that also require some quality control. If you have kids at all or are a Disney fan, Disney licenses to everyone. Everybody makes Disney stuff. So things like that, if it's something that you can license out or even franchise out, those are all licensing agreements that you can monetize. And as I mentioned, you do need to continue to monitor and enforce your marks. Sometimes it's not the most pleasant thing if you find somebody else using your mark or about to use your mark, but it does come up. So there are monitoring services that can help you do that. I don't think I've left any time for Q&A, so sorry about that. But I hope I was able to answer some of the questions that you had at the outset. If you need more one-on-one time, I'm happy to talk with you. There's a link here. The QR code I think works better. The little short code goes to a weird page. But if you click on continue, it'll take you to the sign up form for a consultation. And thank you for hanging in there with me. Although we're a little bit over time, I'm going to kick it back to Catherine, but I just wanted to thank our hosts for today and thank you all for joining me.
Thank you so much, Tammy. Are you open to two questions? Two questions?
Yes, I am. If people want to hang out,
Okay.
I can definitely hang out a little
Okay.
longer.
Okay. So Tammy put the consult QR code. I know some of you had very specific questions regarding your industry and business, so that 20-minute complimentary space might be a really good option for you. So what I'll do is I'll pick kind of two broad questions that I think could be helpful to the broader audiences. Um, so if a name that you submit gets rejected, can you submit name adjustments? Like the Apple one that you had given an example to at the beginning, can you submit adjustments?
Um, no. What you submit is, well, actually, that's not entirely true. Um, so it's all the two most important factors are the mark itself and the goods and services that you're offering. So that's what they're going to examine and compare to other marks in the registry. If the trademark gets cited and there's another application or registration, you can potentially remove certain services, goods or services from your application. You can't add anything. You usually can't change the mark at all. Even if it's like S, like a plural, like making a word plural. So you basically have to start over if it's a refusal that you can't overcome by like dropping something from the application. So usually that would be dropping either a class of goods or services or specific descriptions that conflict with the other mark.
Thank you so much. And I know hopefully not too much of a curveball on this one, but it is a question I do see a bit. So great question to this from this entrepreneur. So I found that legal services with Fiverr that are doing trademarking, which can be, from their perspective, much more cost effective potentially. Would you recommend against that? What are some of the considerations for an option like Fiverr, especially considering small business owners have tight budgets?
Yeah, so there are various online services. There are even some law firms that do it for a flat rate. And I feel like, you generally get what you pay for in terms of the level of service. And that might work for you if your mark is very distinctive and um, has a good chance of registering. Um, the approach is a little bit different. I think with those types of services, they don't do as much of the analysis. They will likely just submit your mark with the goods and services that you plan to offer. Um, and if you, they might do a search. They might not have the legal background to advise on the implications of the search if they are on the complex side. Like it really depends. It could work for some people. Um, if everything is like really simple and straightforward, that's why they're out there. It's doable. But if there are any sort of complicating factors, then you might need some more specific advice to overcome any sort of refusals. So, um, you might end up spending more if you haven't had necessarily like a consultation or legal advice, but it really depends on your mark and the goods and services that you're going to offer.
Excellent. Thank you so much for sharing with that because I know that's something that business owners are looking at. And so, like anything, when you're considering hiring services like an attorney, an accountant, a bookkeeper, do your research, get those estimates, ask them what is their payment plan. And find recommendations and referrals from other entrepreneurs. What was their experiences? And you always want to find somebody that is aligned with your industry and your needs and you as a person. Just like we pick our hairdressers maybe because we connect with that, same thing applies for other services. You want to make sure that you feel very aligned with those that you're working with. Tammy, thank you so much. And for those of you whose questions we didn't get to, I apologize. Again, Tammy does have that 20-minute consult, and that could be a really great space for those types of questions. So with that, I want to thank everyone. Thank you so much for those of you who hung on with us. I know that was a lot of great content, so I appreciate you all and your time. Tammy, appreciate your expertise. And your content today, super helpful. I'm getting great comments in the chat, so valuable. For our attendees, excellent questions, excellent comments. It's been such an active chat, and that is so fun. I see you all speaking to each other in addition to speaking to me, and it just makes this experience so enjoyable to hear your feedback and comments and questions. So thank you. The Women's Business Center of Northern Virginia was the host for today. We want to thank our partner, the Maryland Women's Business Center. You all were seeing some great upcoming programs, so please join us, the Maryland Women's Business Center in Northern Virginia as well too, and connect with your local Women's Business Center. We're across the nation. So over the next few business days, I will provide a follow-up by email with the recording and the slides. So hopefully you can keep the learning coming. This conversation doesn't stop here. I wish you all a great rest of your day. Tammy, again, thank you so much.
Thank you. Take care, everyone.
Bye bye, everyone.